traffickers, incestuous abusers, coercive boyfriends and husbands all have access to these pills now because of the FDA's actions.
The Charlotte Lozier Institute has posted a number of interactive steps one can take at www.lozierinstitute.com. This is SRN News. A dangerous roller coaster ride in North Carolina has been shut down.
An ongoing investigation by North Carolina's Department of Labor has found that a large crack in the support column of a roller coaster had been visible for at least a week before the amusement park shut it down. Carowinds Amusement Park has announced plans to repair the ride and says it will implement new inspection procedures. Video of the Fury 325 roller coaster showed the beam bending and the top of it visibly detached as cars with passengers whirled by. Park staff and ride manufacturers determined this week that a fracture had formed along a weld line in a support column. They plan to remove and replace it. Keith Peters reporting.
Former President Jimmy Carter and his wife Rosalynn are celebrating their 77th wedding anniversary. At 77 years, the Carters hold the record as the longest married first couple ever. And the year comes with both of them facing serious health challenges. More on these stories at srnnews.com.
The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Good morning and welcome to another edition of the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, and we will be with you for the next hour. Today is Saturday, July 8th, and your number for free legal advice this morning is 877-943-9673. Again, our toll-free studio line to reach me, Attorney Patrick Smith, this morning for your free legal advice. If you have any legal questions at all, that is what we do every Saturday morning on the Attorney Patrick Smith Show. We make ourselves available, bring the law office to the airwaves to answer your legal questions. So if an issue arose this week, either in your life or a friend's life, you can call in now with your legal questions. And that number, 877-943-9673. You can also email us your questions, patrick@attorneypatricksmith.com. Again, that email address, patrick@attorneypatricksmith.com. So feel free to give us a call or shoot us an email if you have a question, and we can help you in any way possible. Local Central Florida attorney. For those of you new to the program, I'm Attorney Patrick Smith, and we do this program every week to help you. So we have offices throughout the Central Florida area, Clearwater, Sarasota, Sun City Center, and also over in the Villages and Claremont, all across the Sunshine State to better serve you. But every Saturday morning, we go on the air to answer your legal questions. So give us a call now, 877-943-9673. We have us in studio. We have Peter the intern, Lexi the intern, and Yumiko the producer, Brian, standing by to screen your calls this morning. So give us a call now, and we'll be happy to help any way that we can. I wanted to start the top of the show with a discussion of a recent defacing of Rome's Colosseum. That's right. According to Inside Edition, the title of the article, "Tourist Apologizes for Defacing Rome's Colosseum," says he didn't realize it was ancient. In a letter dated July 4th and addressed to Rome prosecutor, the mayor of Rome, and the municipality of Rome, the tourist was caught on camera last month using his keys to etch his name and his girlfriend's name into a wall on Rome's historic Colosseum. Now, the apology letter basically said, "I didn't know it was old." And here's my question. What if it wasn't old? Does that make it okay? It's not your Colosseum. You can't start just carving your initials into things because they're brand new. As opposed to, anyway, it goes on to say the man has been identified by his lawyer as 31-year-old Ivan Danilov Dimitrov, according to the New York Times, and the letter was published on Wednesday. He quote, according to Mr. Dimitrov, "I admit with deepest embarrassment that it was only after what regrettably happened that I learned of the monument's antiquity." And again, I don't see that making any difference I'm sorry. I just think maybe a different level of punishment, but you still don't go around carving your initials into things, whether they're old or new. He says, through these lines, I would like to address my heartfelt and honest apologies to the Italians and the whole world for the damage caused to an asset which, in fact, is the heritage of all humanity. He also writes in his letter, I am also aware that similar conduct in my country would have resulted in much more serious consequences. And Lexi, we were talking before the show about what that meant. Now, the name certainly sounds Russian. You said apparently, according to your additional research, he is in fact Russian, correct?
Yes.
So Russian, but living in England.
Yes.
And what did you find the punishment to be in Russia? Did you find that information? So according to what I see here in Russia, if you're defacing a monument, it carries a fine of up to $64,000 and 5 years in prison. In England, it's a 10-year potential prison sentence. So either one more significant than the punishment that Mr. Dimitrov is potentially facing in Italy, which is a punishment of fines up to $16,000 and 5 years in prison. So apparently it took 5 days for the police to trace Mr. Dimitrov back to England. And in case you're wondering what exactly he carved into the precious Colosseum, it was Yvonne plus Haley, 23. That is now forever part of the Colosseum's historic history. So anyway, another example of, I don't think ignorance is an excuse here. I don't know. Lexi, what do you think? Do you think the fact that he didn't know that it was old made it better somehow?
Oh my gosh, absolutely not. But I was just thinking, imagine if like they break up and at some point one of them goes back to this Coliseum and it has their initials on it for 2023 and it's, ooh, that was a bad chapter in my life.
Or what if he just decided to fix it? Be like, guys, I got this. I'm going to go, I put it there, I'll take it off. Like, no, great point. Like, I mean, why would you do that? Like, it doesn't make, you don't go around defacing public property. So, Peter, you're recently married. Have you carved your name into any precious monuments?
I have not.
Okay. See, it's not a normal thing to do. I don't think that that's typical. And what if it was something precious to us here in the United States? What if it was the Statue of Liberty? Or what if it was the Lincoln Memorial? I mean, you can imagine the outcry over something like this. So the fact that they're even giving it any sort of credibility, the fact that he's saying, I didn't know. I don't know. That's not a justification in this particular case. So if you have a thought on that or what the punishment should be, 877-943-9673, 877-943-9673. That's your live and local studio line. This is Attorney Patrick Smith, and you're listening to the Attorney Patrick Smith Show, where we answer your legal questions absolutely free of charge. You're also welcome to email your questions, patrick@attorneypatricksmith.com. And speaking of attorneypatricksmith.com, that is our website. Free to you and available 24/7. If you want to check out all of our office locations, you can check out our various podcasts of prior radio shows. You can request an appointment or request to book us to come out and speak to your group absolutely free of charge on a topic of your selection. All that's available at attorneypatricksmith.com. But to talk to us live today, 877-943-9673, 877-943-9673. So I gave the interns a special assignment this week. We are probably midway through the summer internship process, and it's great that we have Peter and Lexi, the interns, here today, because Peter, the longest running intern, current record holder at 4.5-ish years, I think, and Lexi, this is your second summer, so you guys are the two veterans sort of the intern group. And what I asked the interns to do was say, hey, independent of each other, because there's 8 of you guys, I think, at this point, write down the most frequently asked questions that you've observed in your internship. And I said these can be questions you've had or questions you've heard clients, and you guys did not disappoint. And it was really heartwarming for me, everything you guys are soaking in and learning in the internship process. But the one question you all hit on, every single one of you, and it's basically question one for everyone, was, what is the difference between a will and a trust? Peter, go first. What's the difference?
Well, a trust is a private document that avoids probate, while a will is a public document that must go through probate.
Well, and the fact that you hit on the privacy provision of the trust, that's sort of the forgotten about element. Everyone talks about trust avoid probate, and they do. Assets in trust avoid probate, and you provide for incapacity planning. But everyone forgets the privacy portion. So if you're dealing with a sensitive, private family matter, it could be, addressing a child's adoption. It could be addressing the omission of a child or the fact that a child has a substance abuse problem, something. If you make mention of that in the will, Peter, that's public record, right? Right. So you can keep these sort of sensitive, private family matters private by not having them mentioned in a will, but utilizing those privacy provisions of the trust. And every single, intern hit on this, the fact that it avoids the probate process if you create a trust. So that saves you potentially 6 to 14 months and 3 to 10% in fees if you're bypassing a probate process that would have otherwise been formal. The trust also builds and adds on what we call incapacity planning, so that if you don't die, but you're just incapacitated because of a coma or you have an accident and you're somehow diminished and cannot operate your own financial ship, you've designated someone in your stead, or if you're permanently incapacitated and require some sort of nursing facility, it's a great way to make sure that your assets are protected for you and your family by selecting someone ahead of time. So every single intern hit on the fact that it's will versus trust and sort of the advantages there. So Peter, let me ask you again as a follow-up, should everyone at least have a will?
Yes, everyone should at least have a will. I still think everyone should have a trust just in case, and just because it has so many more benefits, just like planning in case you can't make choices for yourself anymore. If you have just a will, you have just a will, but a trust kind of plans for everything.
Yeah, the point is the biggest mistake, and we talk to clients about this all the time, the biggest mistake we see in estate planning is people simply don't do it. And I think that, a lot of times people are deterred by the cost of estate planning. That's why we publish our rates. Our trust packages are $695, and I haven't changed that in the next September will make 17 years I've been in practice, and I've never changed that package rate. It's still $695 for the trust package. That includes the trust and all the accompanying documents, the power of attorney, the pour over will, healthcare surrogate, living will, the deed for the home. A simple will at my office for my entire practice has been, and as far as I plan, will forever be $75. I price it there so that I know that everyone can afford to at least have a will. And the will's an important document because you lay out who's in charge. If you have minor children, you lay out who's going to finish raising those minor children, which is a key concern for a lot of people. And you keep the state intestacy provisions out of interfering with what you would have wanted because you took the time to memorialize it. So power of attorneys are $95 and living wills are $50. That rounds out our fees. Those are published on the website and in numerous ads that we run. But we do that so that people aren't nervous or anxious about coming into a law office and getting hit with a big fee out of the blue. You can walk in and know what the fee will be at our office for those estate planning services that we provide. So again, if you want to set up your complimentary estate planning consultation with us, 877-754-6764 for the early morning crowd. I'm going to give out that office line if you want to schedule your complimentary estate planning consultation in Clearwater, Sarasota, Sun City Center, or any of our other office locations. One easy toll-free number to call, 877-754-6764. All right, if you want to be part of today's show, 877-943-9673. Again, our toll-free number, 877-943-9673. This is the Attorney Patrick Smith Show, and we're going to go to Judy in Lakeland. Judy, welcome to the Attorney Patrick Smith Show. How can we help you today, Judy?
Well, I'm commenting on the Colosseum carver.
Go ahead, please.
And, well, thank God he was not an American. Maybe our educational system is not the worst in the world.
Judy, thank you so much. I knew someone was going to take these lemons and turn them into lemonade and find a silver lining. And Judy from Lakeland, well done, because that definitely makes a good point. How do you finish school and not realize that the Colosseum is old? So I wonder this, Judy, do you think maybe he could go on to say, well, I knew the Colosseum was old. I just didn't know that this building was the Colosseum. Do you think that's going to be the next pivot?
Dumb is dumb. Stupid is stupid. I really have no idea. I guess impressing his girlfriend was uppermost in his mind, and I hope that he has learned a lesson at long last.
Yeah, there's nothing wrong with, trying to impress a significant other. I think, every guy at some point is probably guilty of that fact, but I think when it requires criminal conduct, that's probably where we draw the line. And the only reason why I really believe the guy is because it doesn't make much of a difference. Like him coming out and saying, I didn't know that it was old. Like, you have to hear how that doesn't make much of a difference. So that's probably why I believe him and that it's true that he didn't know that it was old, because it doesn't really change anything. You still did it. And I don't know. It's just one of those things. It doesn't feel like a lie because of how foolish the statement is. Does that make any sense, Judy?
Yeah, it reminds me of that song, I Didn't Know the Gun Was Loaded.
Great point. Great point.
Anyway, you guys have a wonderful day. Patrick, I love your show. You're a wonderful man.
Oh, Judy, you're very kind. I appreciate your kind words and faithful listenership. Okay, have a great day.
You too.
All right, bye-bye. All righty, the number to be part of the show, 877-943-9673, 877-943-9673. You can give us a call now, and we are live and local. Open studio lines. Judy Hanging Up does open up a studio line. So if you have a legal question you want to talk about, as she said, the Coliseum Carver case. I like that. I don't know if that Judy made that up, but that's well done. 877-943-9673 to be part of the Attorney Patrick Smith Show today. So I want to talk next, before we go to Lisa in Spring Hill. And Lisa, I appreciate your patience. You'll see why in just a moment. The new statutes that went into effect, there were several. We did a piece last week on Florida's constitutional carry, but there were lots of new laws that went into effect on July 1st, and many of them related to homeowners association. So with regard to 3 Florida statutes, 718.113, 720.304, 720.305, and you're saying, Patrick, why are you reading the statutes? Because there are listeners that will look them up. They email me, trust me. So 718.113, 720.304, 720.3075. Here's the essence of these HOA rules. Basically, as a matter of public policy, these statutes say HOAs are a little bit of a wild west right now. So the state is stepping in to kind of rein in some regulation of these HOAs that are sort of getting a little ridiculous in the state's opinion regarding these restrictions on things that you can and cannot do. So number one prong of these legislative pieces has to do with storage. And here's the short version on this particular piece of legislation. An HOA may not restrict a parcel owners from installing, displaying, or storing items on a parcel which are not visible from the parcel's frontage or from a parcel adjacent. So basically, if you can't see it, you can store it. That's the short version now under this new state statute. The other provisions have to do, believe it or not, and I can imagine how often this gets debated in HOA communities, what types of flags you may fly on your property. So there's rules about the height of the flagpole and all time, but it really gets down to which flags can you display? And there's a list. These are the flags that you are permitted to display. United States flag, obviously. Florida flag. Flags that represent the U.S. Army, Navy, Air Force, Space Force, Marine Corps, or Coast Guard. Space Force. I want to see a Space Force flag when I drive through my neighborhood. The POW MIA flag. First responder flag. I did not know that existed. There's a first responder flag. They certainly deserve it. Correctional officers flag. 911 operator flag. Nurses, federal law enforcement officers, search and rescuers. Currently not allowed, if HOA prohibits it, according to this, are sports teams and pride flags. So some new HOA regulations that went into effect. And speaking of wanting to discuss HOA, let's go to Spring Hill and let's talk to Lisa. Lisa, welcome to the Attorney Patrick Smith Show. How can we help you today?
Hi, thanks for taking my call.
You're welcome. Lisa, can you turn your radio down for me?
Well, let me do it this way. I'm sorry. I'll have to go back, get it off of.
Oh, are you on hands?
Okay, is that better?
Oh, much better. Thank you so much, Lisa.
But I can pull over. That's no problem. So my question is, we have admitted what we did wrong with the HOA. That's kind of a big, long story. We had an agreement on how to make amends for it. They reneged on it, changed the deal. Now they're suing us. One thing and another, we can't find an attorney to represent us in court. So obviously we're going to get hit with probably a lien of about $11,000 or more, depending on how many more attorney fees they can tack on. So my question is,
go ahead.
Sorry,
I was going to say 11,000 per homeowner, or 11,000 total.
11,000 per us.
Okay.
Just us
Got it.
individually.
Got it.
So my question is, with liens in Florida placed by an HOA, is that like, do they get interest, and what happens with that? We're new to the state of Florida, new to an HOA.
Yeah, so you agreed to their ability to place a lien and charge interest or whatever the second you signed into that community. So that within those bylaws of that particular HOA were these terms about when they can place a lien, whether or not they can charge interest, what interest rate they can charge. So you really have to take a good long look at those bylaws, Lisa. And as far as an attorney, if you don't have one, give me a call at the office, and I'll be happy to put you in touch with attorney Scott Smothers, who's made an appearance on our show, but he does a lot of my homeowners association cases. And that's sort of one of his primary practice areas, in addition to just general civil litigation. But HOA law is something he's quite familiar with.
Oh, okay, great. I'll do that then.
All right, Lisa.
And so with the state of Florida, is it, will it accrue interest?
Well, it's all going to come down to, I think that more than likely they are permitted to charge interest, but I think to do that, they would have to have that in the bylaws. So I think that would have to be an agreed upon term in the HOA bylaws, that if you fail to comply with some assessment of the HOA, I think it's a matter of saying that, you know, the bylaws allow us to do A, B, and C, and you've agreed to that. And that includes that lien. Because remember, the general rule in Florida, under our constitutional law, Article 10, Section 4 of the state constitution, your property is free and clear of any creditor claim, except for mechanics liens or state property tax. At the end of the day, the HOA is basically getting you to yield some of that constitutional protection, but that's exactly what it is. It is the resident saying, in exchange for getting a nicer community, we're going to take on these restrictions and basically weaken our property ownership a little bit by allowing this enforcement mechanism known as a lien for those who fail to comply.
Okay.
Does that make sense?
It does.
All right. Well, Lisa, we appreciate you calling in, and it says you're listening on 102.5 The Bone. Is that right?
Yes,
all
absolutely.
Right. Well, we appreciate you and all our other Bone listeners out there.
Thank you, and
all
I'll
right.
be calling your office.
Lisa, I'll look forward to it. We'll get you squared away, okay?
Thank you much.
You're welcome. Bye-bye. All righty, 877-943-9673. This is the Attorney Patrick Smith Show, and we started off the show talking about our, as Judy monikered him, the Coliseum Carver. I love that. And then we went into talking about the interns and their assignment of coming up with their top 10 frequently asked questions. And I planned on ending the show with that HOA piece, but Lisa actually expedited us getting to that with her HOA question. So call in with any of your legal topics on those matters, or if you have a completely different legal question, you're welcome to call in. Lisa hanging up does open up a phone line, 877-943-9673. 877-943-9673. And before we go to Paul, Lexi, you actually have a story about a run-in with an HOA. Is that right? Are you the Yvonne Dimitrov of HOAs?
No, I wouldn't say that far.
Okay. So tell us your story. What was your run-in with HOAs?
So I'm currently staying with my sister over the summer, and I currently park my car on the side of the street, but like on their grass, just because they have to move their cars in and out of the area. So I don't want to restrict them being able to drive. And the HOA leaves these cute little notes on little flower paper with a very passive aggressive message telling me to move my car. I haven't moved my car yet.
So can you take a picture of one of these notes next time you get one?
Sure.
Okay. I want to see what the note says. So there's someone who's obviously like enforcing this, and they walk around and kind of patrol. Now, does it threaten any sort of action, or is it just like a, hey, move your car?
It's a, hey, move your car. They haven't sent anything to their house.
How do you know it's the HOA?
They sign it HOA.
Oh.
Now, I know who it is that does it. They ride around on this little like motorbike, and they go around like they wear this like green, like bright green vest.
Well,
and
safety's first.
Of course. And they have this like little flag that sticks up over their like little motor vehicle, and they run around with their little notepad. I don't know if they're the self-claimed HOA, if they're really the HOA.
Because anybody could write HOA on a note.
Right.
So have you been tempted to find that scooter and leave a note of your own and write HOA on it?
Oh my gosh, no, I haven't, but I will.
Well, you didn't get that idea from me. So, all right, 877-943-9673. And can we quickly tell, you said you were parking. Can we tell your parking story? How do you how do you park on the street? Are you just pulling up to the curb?
Yep. Just
so that's super easy.
Mm-hmm.
So tell everyone, when I noticed one day, everyone, Lexi always backs in to her parking spot. And I noticed it was a thing whichever office, wherever Jennifer will be with you in just a moment, wherever Lexi was parking, she was always backing into the place. So there was a point where I was like, hey, what's your reason? Because I find when people back in, they usually have a reason for it. And Lexi, share with everyone your reason for not being, why you always backed in.
Well, to first start, I'm a champion back inner. But second reason, I can't pull into spots.
Well, but
I thought I couldn't.
Right. So, and now when you back in, use the camera.
No, I usually use the side mirrors.
Just the side mirror. See, I thought you were cheating and using like a backup camera.
No, I've run over the curb before using the backup camera.
So the backup camera actually makes it tougher for you.
Yes.
Okay. So we tested this theory last week. I said, hey, Lexi, when you're in the parking lot, let me know. And tell them the result of you parking normally.
It was perfect.
Right. And so the point there, we're helping Lexi realize the only thing limiting Lexi is Lexi. You can park normal. Like, you don't have to always back in. Like, back in, that's your thing. But don't back in because you can't park the other way. So now you know you can park either way. Anyway, Jennifer in Fort Myers, thank you for your patience. Welcome to the Attorney Patrick Smith Show.
Thank you for taking my call.
Sure.
So I was asking about the new alimony reform that just got passed, specifically to existing permanent alimony payers who have modifiable agreements.
Yeah, so this is a topic that is popping at the office this week. I've gotten several calls on this, and I'm actually working with lining up a family law attorney to come on the air to discuss this particular piece of legislation. But Jennifer, what I will tell you is that, number one, I don't do family law. But number two, if you give me a call at the office this week, I will put you in touch with a family law attorney that can give you a complimentary consultation on your situation, how this new law affects it, if it affects it, and where you go from there.
That's amazing. Thank you so much.
Of course, Jennifer. We appreciate you listening, okay?
Thank you.
Have a great Saturday. All righty, 877-943-9673. 877-943-9673 to be part of today's show. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. All righty, let's go to, is that right? New York? Let's go to Paul in New York. Paul, welcome to the Attorney Patrick Smith Show.
Thank you. Good to talk to you, Patrick. I'm in Chautauqua, New York, listening to you from the Sarasota station on an internet radio.
That's AM 930?
That is correct.
All right. Well, we appreciate you listening, Paul. And you said it's pronounced Chautauqua?
No. Chautauqua.
Chautauqua. I'm guessing that's a Native American word.
It means... I can't tell you on the air what it means.
Okay, we don't want to hit the dump button. That's okay. I appreciate your honesty and candor, Paul. How can we help you today?
We have a house in an LLC. And whenever we bring that up, people who have trust say, oh, we don't need an LLC. We have a trust. And I would like to know from your opinion about what the difference is between those two and which is better to put your property in if if you have to.
I think it depends on the nature of the property, Paul. I think if we're talking primary homestead property, so this particular, in your question, is the property at question the primary residence?
It is not a primary residence. It is, our primary residence is in Florida, but this is a vacation house.
Okay.
We have upstate New York.
Is it a vacation house that anyone else occupies besides you?
No.
So it's not a rental. It's not an income property.
No. That is correct.
Yeah. From a Florida law perspective, I say that property goes straight into the trust. I don't think you need the LLC for that. However, if the facts change and that property turns into a Airbnb for you or an income property of some type, the liability likelihood skyrockets for you, Paul. And in that particular circumstance, and if it's a New York property, you're going to need to consult New York counsel on this. But in Florida, what the rule would be is drop the property, presuming it's free and clear of any mortgage or encumbrance, into your LLC, and then have your LLC, through the membership certificates, transferred to the trust. So you've got the best of both worlds. All the layers of protection are in place. The liability.
Okay, let me say.
Go ahead, Paul.
Yeah, go ahead. The reason we put it in an LLC in New York State specifically is to avoid probate. We wanted to give it to our children, and sometimes it takes a year and a half to go through probate in New York State. So specifically, we put it in the LLC, not necessarily, liability is good, that's of course, but we're trying to avoid all the other legal stuff we have to go through.
I would love to talk to the New York attorney that did that, because this is the first time I'm hearing in New York State, and I've worked with lots of New York attorneys over the years, about using an LLC under New York statute to avoid probate. I've heard of trust commonly over the years, but this is a first for me, Paul. So if you want to call me off the air at the office, give me your attorney's number. I would love to have a conversation with them, because it's definitely a case of first impression that someone is using an LLC as a testamentary vehicle. I've never heard of that before. And my question would be, in Florida, at least, if you have an LLC that's owned by someone and they pass away, how do you get it transferred to the beneficiaries?
Well, our children are beneficiaries of the LLC.
And see, that's a completely foreign concept to me, that you have a beneficiary clause in an LLC. It just seems counterproductive. It seems like you're trying to use a boat to drive down I-4. It seems like it's the improper vehicle to get to where you want to go. But I'll suspend disbelief, because one thing I'm not, of all the things I am, Paul, is a New York lawyer. And if there's some New York statute out there, I'm willing to learn. This sounds cool and different, and I would love to hear the rationale from the New York attorney about how this mechanism works, because I'm fascinated with what you're saying.
Okay. Well, I will be happy to give your office a call. And do I have that number?
Yeah, the office line. And for everyone else listening, if you want to call the office to schedule your complimentary consultation, again, our toll-free office line, 877-754-6764. 877-754-6764. But Paul, thanks for calling in. Absolutely fantastic question.
Thank you.
Good
to talk to you.
Yes, sir, Paul. Enjoy New York. Bye-bye. All righty, 877-943-9673. Paul hanging up does open up a phone line for those of you trying to get in. 877-943-9673. I'm Attorney Patrick Smith. This is the Attorney Patrick Smith Show, and that is the number, by the way, to call for your complimentary consultation. 877-754-6764. That number, the office line, to schedule your appointment. 877-754-6764. We're getting so many phone calls, Peter, now. We had to hire a second full-time phone person. Yeah, they were telling me that as one line rings, there's 5 more calls trying to come in. So we're like, yeah, we're at that point. And a lot of that's due to you, the Attorney Patrick Smith Show Nation, all you guys listening out there calling the office, and we appreciate all the support. And like Judy said, her kind words about the show, we get that daily, and we just appreciate it so much, everyone encouraging us and supporting us in what we do to give back to you, the community, with our free legal advice show we do every Saturday morning. So 877-754-6764, that office line. But to be part of today's program, 877-943-9673. We've been talking about the Coliseum Carver, as dubbed by Judy from Lakeland. We've been talking about new HOA laws and the intern frequently asked question log as well. So before we go to our next caller, Peter, the next frequently asked question that the interns came up with was a great one. And this one actually comes from Brittany, the intern. What is expected of a trustee?
A trustee is expected to act in the best interest of the grantor.
And that's a great answer, because it indicates that there is a fiduciary duty between the trustee and the grantor. So it's best demonstrated, initially when you create your trust, you're the grantor, you're the trustee. Obviously, you owe yourselves those duties, but it seems silly because you're in both roles. So the better question here is probably to modify it slightly and say, what is expected of a successor trustee? And Peter's answer is perfect. You have a fiduciary duty to maximize the protection of the grantor or the beneficiaries of the trust. Kind of a job description. When people ask me, and we're picking a trustee, and they say, well, what does this person need to do? A trustee's job is sort of marshaling assets, gathering all the assets, paying the debts, liaising with the Internal Revenue Service and timely filing all tax forms, preparing the formal accounting, sending out trust notices, and ultimately distributing the funds pursuant to the decedent's wishes. So that's sort of the job description. And that's, the level of detail that these interns are soaking up about. And Peter, the reason why I went to you with that question is the 4.5 years, you've seen more as far as not only just the drafting side, but the postmortem administrative side. So you've seen me serve as a successor trustee, and you've sort of witnessed it firsthand. Does anything stand out to you as far as being a trustee?
I think just the level of work that it takes. I think a lot of people hear that a trust is easier than a will in regards to the probate and to the process, but they don't realize that still, like marshaling those assets, selling a property if there is one, filing all the tax documents, getting everyone in order to send them the money and splitting up the funds. It's a lot of work that people don't realize.
It's easier because you don't have to go through probate, and that certainly makes it a lot simpler when all the assets are in the trust and we bypass probate. But that doesn't mean there's not any work to do. There's still some work, and just because you eliminate probate doesn't mean there's some effort to, like you said, do all those jobs, gather the assets, pay the debts, do the accounting. There's still some level of effort required for a trustee, and they're allowed to be compensated. And that's why the code says a reasonable fee, reasonable as blessed by the beneficiaries. The trustee will present that reasonable fee, which is usually around 1%, according to my experience. And that will go in the formal accounting to the beneficiaries, and they have 30 days to review, question, object to the fee if they believe it's wrong, along with anything else in the accounting. So there's a procedure there by which the beneficiaries are the policing agent that determine if a trustee's fee is reasonable or not, as opposed to the trustee just deciding unilaterally. So 877-943-9673. Let's go to Oldsmar next, and we're going to talk to Sharon. Sharon, welcome to the Attorney Patrick Smith Show.
Good morning.
Good morning.
I enjoy your show. I wanted to know what would be the procedure if you cannot currently find a copy of the will of your deceased parents, but you need it for current transactions or just documentation to show that you inherited a piece of land.
Well,
everything went smoothly when my mother passed, but through several moves now, I can't seem to find it. And I just wanted to know, is there a procedure if I needed to get a new copy?
Yeah, it's a great question. So, Sharon, did your mother pass away as a Florida resident?
Yes.
Okay. And you had an attorney represent you in that probate?
Oh, there was no probate, really. She had everything laid out for my brother and I, and everything was 50-50. And we had no problems. It's just that she left us. It passed on from my parents to us. It's just a piece of land in South Florida, which is on the books. It has my parents' name, but we need to, at least if we wanted to do something at some point, we would need to show ownership or have it transferred to our name. And just can't seem to find it right now. Everything else was just fine, split down the middle. And, but still.
It sounds to me like that property in South Florida is going to have to be probated. So the Florida state law, 732-901 is the statute, says the will, the original will, is due to be put on deposit with the clerk of court within 10 days of your mother's death. Was that done?
That I do not No.
Well, I would start there. Go to the county of your mom's residency. If it was put on deposit, you can go down and get a copy, and it's usually about $1 a page. There'll be some copy fee. Some counties don't even charge you anything. It just depends on the county. And you go down there and say, I would like a copy. Because as we started the top of the show, one of the disadvantages of a will, they are public record, but that can also be an advantage. Like in your case, I need a copy of the will. You can just go down to the county. If it's recorded, it's right there. If that doesn't work, meaning if it wasn't put on deposit, I would say try to find out who the drafting attorney was and contact that attorney's office and see if you could secure a copy from that attorney.
Okay. All right. Well, thank you so much. I appreciate it.
You're welcome, Sharon. On what station are you listening?
I think it's 102.5.
All right. 102.5 The Bone. We appreciate you, Sharon. Enjoy the rest of your Saturday, okay?
Thank you.
All righty. 877-943-9673. This is the Attorney Patrick Smith Show, and I'm Attorney Patrick Smith. And we're with you for about another 10 minutes to answer all your legal questions. So give us a call now. Sharon hanging up does open up a line. 877-943-9673. All right, let's go to a very patient Joanne in Sarasota. Joanne, welcome to the... Joanne, is this our regular Joanne?
Yes,
Hey,
indeed.
how is life, Joanne?
It's good. I'm vertical and moving forward.
That's so much better than the alternative, my dear. It's great to hear from you. How can we help you today?
Well, at the beginning of the show, excuse me, you mentioned that a will goes to probate where a trust does not.
Correct.
Well, I am looking at mine, and it says last will and testament, and it was done in 2017. And it seems very complicated and convoluted and thick, and I don't think my estate is that big. Inside of the cover page, there's a table of contents, and
That's how you know it's good, Joanne. When there's a table of contents and the author's biography on the inside cover, you know it's going to be a great read.
It's going to be what, please?
It's going to be a great read.
Okay. It just seems so heavy because, you know, I'm not a Rockefeller. Let's put it that way. So you're recommending to redo this, I would think.
Well, I don't know. I can't give an opinion on a document I haven't yet laid eyes on. So we have the Sarasota office, as you're aware, I'm sure. And I would just say, call the office, complimentary consultation, Joanne. It'll be great to meet you in person. Bring that document in. I'll put eyes on it. And then, you know, I know it seems a dense document to do to you, but having done this as many thousand times as I have, we can get through the document pretty quickly with you as far as.
The second question is, there's a bit, you're familiar with the Meadows, are you not?
I am.
It would be nice for you to speak here because it covers a lot of the, you know, it's a very big place.
Well, we're just a little bit like vampires like that, Joanne. We have to be invited.
Well, you know, I would arrange that if I can.
But once we're in, we're in. So, yeah, no, absolutely, Joanne. If you want to set that up, I would love to go and speak at the Meadows. And for those of you listening, if you have a group out there that needs a speaker, we lecture all across the state on wills and trusts, charitable giving. We speak regularly at the church where Peter's dad is a pastor, Indian Rocks Baptist, on charitable giving and planned giving. So we speak all over the state. And Joanne, I would love the opportunity, and it means the world to me that you thought of me in that regard. Thank you.
Yes. A comment with regard to the young lady in the parking.
Yes, Lexi. She's right here, by the way.
Beg your pardon?
Lexi's right here. Yes.
Okay. You know, these are private roads in here. We have to pay to pave them, etc. What happens when people start parking on the road? In the season, you almost can't pass, if you know what I'm saying. So they should be providing an area for her to park.
So I think you're on Lexi's side here. Yeah, Lexi's not like some sort of rogue delinquent who's, you know, driving. Well, Peter, what was it with that face, Peter? So what? At the end of the day, I think it's a great point, Joanne. She's not driving by open parking spots and saying, "I'm going to park on the street because it's closer." You're right. That's a great point.
So my point is, they usually provide parking for guests. You see. We have one.
I think that's a great idea, Joanne, and I like how you're bringing a solution to a problem. Way to be solution-oriented. Good for you.
Okay, dear. Well, thank you. I will. Oh, excuse me. Can I just have the Sarasota number?
Yeah, well, it's the toll-free number, 877-754-6764.
Thank you very much.
You're welcome, Joanne. Have a great weekend, okay? Great to hear from you.
Bye.
Bye-bye. All righty. 877-943-9673 to be part of today's show. 877-943-9673. This is Attorney Patrick Smith, and this is the Attorney Patrick Smith Show. All right, let's go next to Diane, right back to Sarasota. Diane, welcome to the Attorney Patrick Smith Show.
Thank you. Thank you for taking the call. I have a question. I was going through old papers that my mother had and found an insurance policy that I don't remember about anyway. So so I asked a friend, and he said to, go to Treasure Hunt, Florida Treasure Hunt, so forth. Mm-hmm. But I also called the company, and they said, well, we have no record of it anymore. And so I don't know where to go to now. I couldn't find anything on Treasure Hunt. So what do they do with these policies if they're not, if you're not aware of them?
So sometimes you're right, they will pay into the state fund if no one claims it. But at the end of the day, if this was a term policy, it's possible the policy just expired and there was no death benefit. So that's why there's no record. So mom had a 20-year term, and I'm not a financial advisor. So by all means, Diane, if you have a financial advisor, get with one. If you need one, we've got some great ones we work with. We'll be happy to put you in touch with them. But they need to review that policy with you from the financial planning side. And as far as reviewing it from the legal perspective, we'll be happy to do that if you don't have an attorney, and make sure you understand what, if anything. And we found some this way before where, we thought it was defunct, and it turns out there were hundreds of thousands of dollars that had just been unclaimed because people didn't know about the policy. So it's something worth looking into. It's worth giving a good half-hour consultation to see whether or not it's something that could yield a pretty significant dividend or windfall to the family.
Oh, okay. So what is the number that I call for to find out about your attorney?
Yeah, so to schedule, it's at 877-754-6764. That's the office line to schedule your consultation with me. 877-754-6764. And just bring in all the paperwork you have on that, and we'll be happy to start from there, Diane.
Okay. Thank you.
You're welcome, Diane. Have a great day. All right. This is the Attorney Patrick Smith. Bye-bye. 877-943-9673. 877-943-9673. This is the Attorney Patrick Smith Show. We're going to a very patient Ray in Tampa. Ray, welcome to the Attorney Patrick Smith Show. How are you, Ray?
I'm doing well. How are you doing today?
I'm great, Ray. Thanks for your patience. How can we help you?
Well, I just had a question about a judgment from a credit card debt and selling your home. Can they put a lien on your house, a judgment from a credit card?
Is it your homestead?
Yes.
Did you sign something giving them permission to put lien on it?
No.
Then my answer is no on that one. I think you look pretty clearly at the state constitution, Article 10, Section 4. That's why a lot of attorneys from other states miss this provision in Florida law, because it's not in the statutes. It's in the state constitution, the highest body of law. And it says that home, as long as it fits certain geographic limitations, 1/2 acre within the city limits and up to 160 acres outside of the city limits, it is bulletproof from your creditor claims. We think as a state, it is a good idea as a matter of public policy to make sure you have a place to live. 2 exceptions to that constitutional creditor protection. One, what we call a mechanics lien. If you hire someone to put in a pool and don't pay them, they can obviously lien the property. Number 2, your property taxes. If you don't pay your property taxes, they can put a tax lien against it. Other than that, Ray, it sounds like you're bulletproof on this.
Okay, well, we're looking to sell our house. So I guess that answers my question. Thank you.
You're welcome, Ray. Enjoy the rest of your Saturday, and thanks for calling in. What station are you listening on in Tampa?
102.5.
All right, 102.5 The Bone. We appreciate you, Ray.
Yep. Thanks.
Have a great day. All righty, 877-943-9673. 877-943-9673, or email me, patrick@attorneypatricksmith.com. You can email us 24/7, and yeah, I monitor my own email, checking each and every one of them. So you're welcome to email me, and I'll be happy to respond And sometimes if it's a complicated question, I'll just tell you, call me at the office. It's easier than going back and forth over email. So 877-943-9673, 877-943-9673 to be part of today's show. Give us a call now. And for those of you just tuning in, again, that office line to be part of our weekly calendar and meet with me for your consultation, 877-754-6764, 877-754-6764. And again, we barely touch the surface on your frequently asked questions, guys. We're probably going to have to do a follow-up on that particular segment. So I think what we'll do is just save the rest for a future broadcast. But it was an action-packed show today. We started with the Coliseum Carver. Got into some great in-depth analysis on new HOA rules. We got Lexi's firsthand accounting of her nefarious HOA violation activities, allegedly, and her parking escapades. And we also had some great calls on that as well. So we've enjoyed being with you this last hour. Write the number down for next week. So if you have a legal question that pops up during the week, you'll know who to call next Saturday morning at 8 a.m. bright and early. 877-943-9673. Again, that is your toll-free line. You can always visit our website, attorneypatricksmith.com. Again, toll-free, you can call the office, 877-754-6764. Again, that toll-free office line is scheduled in Sun City Center, Sarasota, or Clearwater. And again, the whole reason we have a Sarasota office, this radio show, because of you great listeners out there. So that toll-free office line, 877-754-6764. And again, you can visit our social media on Instagram at The Attorney Patrick Smith Show, or on Facebook, Attorney Patrick Smith. Give us a like and a follow, and you'll get our video feeds of our weekly broadcast if you want to watch the show. But everyone, have a fantastic weekend. Stay cool out there. Those temperatures are getting high. Make sure you're staying hydrated. God bless, stay safe, and go Gators.
The preceding was sponsored by the law offices of Patrick L. Smith. W282CI Tampa, W271CY Lakeland, W262CP Bayonet Point.
Online at letstalkfaith.com or listen on TuneIn and Odyssey.
Do you like to play games? Well, now you can play free at letstalkfaith.com. Just look for the games banner or click the games tab on the top.